to everybody. Today, I welcome you to this webinar called The Access to Drugs, Impacts and Challenges for Social Security Systems. Today, on behalf of Dr. Daisy Corrales Diaz, we welcome you from the Inter-American Center of Social Security Studies, from the Inter-American Conference of Social Security. Today, we will have a luxury panel. We will have both Dr. Marcela Vargas Peláez, Director and Founder of Pharma Colombia, and Dr. Valentina Delich Flaxo, and also comes from Master's degree of Public Assets and Intellectual Property, and also Dr. Yesenia Rios for the contributive system of the health superintendents and labor risks, and coming from Dominican Republic, and Dr. Daisy Duran Cuesta, coordinator of drugs of the Social Security Equatorian Institute. All these topics invite us to think on the way of socializing experiences on the access to drugs and the successes and impacts on the social security systems. That's why today we will listen to the table that will be the moderator of Dr. Jose Luis Linfo, that is a coordinator and expert in the Inter-American Center of Social Security Studies. So we welcome you all, to all the participants, and also we welcome Dr. Jose Luis Ordelin Onderlifon, that today will be the coordinator of this panel. Therefore, I welcome Dr. Jose Luis, and I will give his bio. He is an expert on the American Commission Judicial and Legal from the Social Security Studies, investigator of the National Center of Researchers. He has a PhD of the School IMED in Brazil, and also the PhD got from Cuba, and he has the master's degree of intellectual property given by the Buenos Aires University. He has a master's degree in civil law from Havana, Cuba, and also he is an expert on the intellectual property, and he has written books and articles edited in Brazil, Cuba, Spain, and Mexico. And he has made investigation in the University of Valencia, University Bonavide, University Alicante, España, IMED, Brazil, and also in the UNAM of Mexico. So we welcome cordially to all the panelists and to the doctor in order to begin the most important webinar of today. Thank you very much, Ana Belén. Thank you on behalf of Dr. Daisy Corrales, Director of the Inter-American Center of Social Security Studies, and also the Inter-American Conference on Social Security Studies. Yes, today we will be talking of a main topic that has impacted the last years, specifically on the last 2 years of the pandemic, the topic of access to drugs and medications, and the challenge it represents for public systems, public health systems, and social security. The pandemic during these last 2 years has shown something that was there. So we need to remember and show everything concerning on the intrinsic complexities of the need to analyze the access to medications. Today we have a luxury panel, not only because they are experts, as we are usually listening to them in these topics, but they are women that have worked for Social Security, and that enriches us and strengthens us. How to achieve a public health system with a Latin American scope? That is the scope that we are pursuing and trying to reach. And how in Latin America we need to think on these health public topics. And today we will talk about two main topics: access to drugs. This is very complex. This can be seen from different points of view. But first, we will be focusing on intellectual property. How much intellectual property achieves its purpose, and how we are having an international dialogue for international commerce. And on the other side of the coin, how the social security institutions are facing the access to drugs and medications, not only for COVID, but for everything and that we are dealing with nowadays. And there is something that we need to emphasize in access to drugs. Today, we are all concerned for vaccines access. This is very important, and we are going to talk about it. But also, please take into account all the diseases that we cannot evade. So when we talk about chronic diseases, we need to talk about cancer and how it impacts the public health sector and the social security systems. And also I want to thank especially the organizers of this seminar, the Judicial Social Inter-American Conference. This is one of the projects of this Judicial Social Inter-American Conference. We are working on transparency and access on drugs, focusing especially on Latin American continent, which mechanisms we are using and how the Dominican Republic and other countries are facing these challenges. So even if out of the Central American region, Dr. Daisy from Ecuador has been participating on this, and Dr. Yesenia as well. And so we need to see this topic from different points of view on Latin American view. And also Dr. De Llano, Maria Lorena De Llano, is the General Director of the Latin American region, and that has been specializing on access on medications and has helped us in the organization of this webinar. Dr. Arguelles, that is the Director of International Relations of the Social Security Equatorian Institute, and is dedicated to the social and judicial topics and persons. And also Dr. Tirsan Kabiurse, Judicial Director of the Labor Risk and Health Public Sector of Dominican Republic. And also, we need to thank Flaxo for the different vision it has for the new ideas on intellectual property and from the point of view of public policies. So I think we need to start the webinar, and all the considerations and the speeches of each lecturer will be heard. So we start with Dr. Claudia. Dr. Claudia Vargas Peláez will talk about the intellectual property and the access barriers to medications in the health sectors. Her bio, she is a chemist, pharmacological expert and director of the Foundation and Pharma that is part of the Latin American Network for Medication Access. Has made research on the design of public policies related to drugs, and also has made investigation on access to drugs, prices, and drugs in Latin America. So well, welcome to the Inter-American Conference and Social Security Studies. You have the word. So good afternoon to everybody. To all the panelists that share the panel with me and the audience, first of all, I want to thank the CISS and Jorge for having invited me. We are representing the Latin American Network for Medication Access. As Jorge says, it is coordinated by Lorena De Llano and is constituted by 5 organizations based in Colombia, Peru, Argentina, and Brazil. And from Colombia, we are Pharma Foundation, an NGO with more than 20 years working in drugs and specifically on the medication access and the intellectual property. We are working on these from the civil participation as well as in the negotiation of free trade agreements between Mexico and United States. Well, we have received its impact even nowadays. Without further ado, because we have short time in the agenda, by introducing my lecture, I will give you an overview of why medication can be considered a health need and which are the factors that influence on the way that we see this particular product and how it impacts economically and socially in the society. On one side, we have a drug that plays two roles on the level of society. First, it plays a role on health because it's a good that is considered social, because it helps us to guarantee the right for health of all people and be part of the healthcare and the resolution of health in people. On the other hand, we have a drug that is considered commercially and is produced by industries that are trying to have profit from its trading. And since 1995, it has to be protected because there are monopolies based on its commercialization, and therefore, for lack of fair competition, the prices can be very high. So, medication is a product that plays a role internationally, and the drug is considered as part of the right to health in international human rights treaties. But it's also involved in international human of trade, for example, as the TRIP, that is in Spanish, the name of the agreement. According to the international panorama, we define the rules and how we care for the health of people. And this is established from the political constitution on how each country understands the right to health. And from there, we establish the rules to organize the system. On the health and on the side of the trade, we have local policies of intellectual property, its trade, and policies of price control. And there also there is the individual level. There is the person that is endowed with rights and can claim for the rights through the health sector or through judicial means that is authorized in the region, or well, as a consumer of health products that can access through a private market or not necessarily through the health market, but through another means. So after this introduction, we will focus on this chart on the side of intellectual property. And first, how we have to define a patent. It's the core of this topic. Well, a patent is a title or deed or protection that issues the state to the inventor in order to have a monopoly, as stated, after 20 years, and protect the investor the person has done in the innovation. And this is a general definition that is applied for everything. We are saying that patents are the same and it can be applied through a cellular or in a medication. But on medication, it creates access barriers to people because usually when the drug is in a monopoly and has no competition, the prices are very high because due to the lack of competition, as head and holder of the patent, I can establish the price I want. So it is regulated internationally by APIC and nationally We have two possibilities. One, by regulated through, uh, uh, for example, in Colombia, by the Nation Andine Organization, there is not a national specific regulation. And also, beside that regulation, when the countries they have free trade agreements, they introduce changes in the regulation of intellectual property, and sometimes it gives longer protection timings, or even and they allow to take another measures to protect intellectual property as for the right, as for example, test rights that can have a barrier to the access or to the competition of generic products in some countries. Patents have had an important impact in public health. Maybe the first time that we saw the negative impacts of patents on this regard was at the beginning of 21st century, and due to the HIV crisis, specifically in Africa. All these drugs were in medications that rescue lives against a disease that was lethal before it was known. But it was necessary to have low cost in order to guarantee the access of the African countries, and this impacted morbidity and mortality in these nations. In that era, the Doha Conference took place in 2001, and there they said that patents are trade topics, but health topics must prevail on those commercial relevance. So the safeguard that exists in the ethic agreement to protect the health public against the adverse impacts of the protection of patents have five options for countries to use. These are the ones that are listed here. First, the country must define rigorous patent criteria. Patents cannot just be issued, but just the ones that have innovation degree. The second, parallel imports. Third, voluntary licenses. Four, obligation licenses. And fifth, public use non-commercial, that is mandatory. And the rigorous patent criteria are important because and the new drugs that not necessarily imply great innovations, for example, a salt polymorphous or a chemical innovation, is not necessary to be patented because it was there in the market before. An example of these are the patent criteria of Argentina. And that is an example that we follow in the region because thanks to the implementation of these criteria, many drugs that in other regional countries have patent, and it was not patented in Argentina. A particular is this sulfurious beer for hepatitis C. It was a patent that was a boom 7 years ago because it healed the disease in that year in Argentina, and thanks that it was not patented, and they examined the request of giving a patent, and well, with that, and they patented it because in other reasons they will have very high costs. So parallel imports, for example, allow a country to import a patented product from another country if the price is less without asking permission to the creator of the patent. There, the holder of the patent, the laboratory holder of the patent, can dominate the market. For example, in Colombia, it can have the holding of the patent, but it can increase the price if it sells it to Brazil. So it is very complicated because of the dominion that it has the producer of the drug that was patented in the specific market, because that defines the price. The voluntary licenses Some of them are implemented in Central American countries, and nowadays it covers the low-income countries. So the laboratory holder of the patent has to authorize a third party, another third company, to manufacture a generic version of that drug. And that laboratory has to pay a royalty to the holder laboratory of the patent. And this has a limit because the holder of the patent has to define the conditions. For example, what is the cost of the royalty and which countries are covered with it. Normally, involuntary licenses, here is an example for hepatitis C. For example, it doesn't cover low or middle income countries, for example, Brazil, Colombia, Argentina. And so we have to bear that burden for not covering those type of licenses. Normally, it is given to markets that are for markets that in which the holder of the patent is not interested. So this topic has motivated a lot of debate due to the COVID because it was an alternative. But what we have seen is that at least in the medium revenue countries and medium high revenue countries, we don't have those means because it has a very high price. So then we have the non-commercial public use. The state defines that a drug is of public interest and authorizes a third party to manufacture the generic, but it is not traded in the private market. It is only used by the government normally to be traded in the normalized market through the health sector. And these tools has been used as, for example, in Malaysia, for example, to trade the sofosbuvir. So these are alternatives that have the countries in the framework of regulating the intellectual property to access drugs of less price. Then we have the mandatory licenses. Here, it's a little bit different to the non-commercial public use, because in this case, the third party that is authorized to produce can commercialize the product in the private market. It is not only for the government, but also the general market. So this type of licenses has to undergo a declaration of public interest of the drug or for emergency declaration. And there the government authorizes a third party to manufacture by paying a royalty to the innovator. And the difference from a voluntary license is that the holder is the holder of the patent. But in this case, it's the government that decides the patent and who will have it for the territory. Well, the paper says that every member country has the right to issue obligatory licenses and define its process. In Colombia, we have had the experience against the obligatory licenses that have been issued by Red Lamb. But that process is very slow, is full of pressures, and it is not an expedite means to guarantee access to drugs under emergency conditions. So the first case, the Caletra, was the combination of lopinavir, ritonavir in 2008. It delayed almost 5 years, and this drug for HIV was given a patent, although the invention was not considered because the drug was already known. And when it was requested until Colombia, there was not an application of obligatory license. So the government started to define the process and took some time. So then the health ministry evaluates if it is of public interest or not. And from the point of view of the Ministry of Health, it was not public interest because it was already covered by the system and the access was guaranteed. However, the price paying the system for the drug was very high because it was a monopoly price. In that sense, and what was done was to interpose a legal action, not of non-compliance, but of a collective amparo. I forgot the name in Colombia, but it was through the court that demanded the Ministry of Health to have a price control for that drug, and that reduced the 90% of the price. So that was the first experience. But as I am telling you, it was a very long process. And then the limatinib case that works on cancer for certain types of leukemias. And it was a request to declare it of public interest in 2014. And it was done because the polymorphous patent initially was denied by the Office of Patents in the country. So the lab interposed legal action and the laboratory demanded to issue the patent. So in this case was an unjustified patent. It was a drug that had an important innovation to treat leukemia. And for that, they decided to start a legal process to have the obligatory license. In the beginning of 2016, and the request was in 2014, but the ruling was 2 years later given in 2016, and the Ministry of Health recommended to issue the public interest in June 2016. The following action was that the Office of Patents needed to declare the obligatory license, but it didn't happen because at that time, the position of the Office of Patents was pro-patent position. It wanted to protect everything, and it didn't happen. So the Ministry of Health established a
A
regulation of
regulation of
prices.
pricing that's different. And because of the fact that we have the pricing, as I've said, it's regulated. It's regulated by an international regulator. You just not only have like generic medications and others and patent ones in the countries that have referenced. This was very tough for this case in general because what happened was that Colombia paid. Originally, they paid the a higher price for the generic medication there, but there were so many things in government procurement. There were some commercial or trade issues. There were threats of receiving some lawsuits in the situation. So that the process is has I mean the process has been delayed. One of the decisions of the ministry in this case, Glivec or Manitivi, was a decision by the government and the licensing of the parties involved. After that decree, since the 70 or 670 as a decree, everything that's of interest of the public, it's compulsory. They closed the door for any other price regulation, like with imatinib. No, that was the bad news. But the last example is about the hypothetical C condition. The cost was of $30,000 in Colombia for a treatment, almost 100,000 pesos per patient. These treatments and medications were an innovation, were very important because we didn't have anything as a safe treatment for hepatitis until then. And what we had to do, because part of what we found with previous experiences, specifically with imatinib as a medication, there was a fixed price control imposed, and the use of other medications or NIBs was simply triggered. It just it was an incremental behavior of it. So somehow there was a neutralization of the pricing control because of the public's interest. Now, what did we do? We petitioned this declaration for public interest, and we have to date, or since 2015, we haven't had a court resolution regarding the process. The court proceedings started and continued until 2017. The ministry sent its petition, submitted its petition, and they wanted to centralize the procurement process from government. And it was an innovation for the Colombian government. Right now, I'm going to talk about this slide. I'm going to go through it. This is the flow of how the Colombian system works. We have different schemes, the contributions, the subsidies, and the mixed or different types of schemes here. What we did in Colombia normally in our system is that everyone that has a benefit from the insurance has a distributor and bought medications. With centralized procurement from government, what happened was that insurance companies have to submit reports to all the Ministry of Health in Colombia with full data to go through the strategic procurement fund, strategically negotiating with the OPS. Now, the result of the medications price is that it's been down. We pay $1,500 for the treatment. There's generic medications that cost $150, though. We can still increase the capacity in our system exactly in that area. We could not have been doing this if these medications were not declared as medications of public interest. However, the centralized procurement process in the pharma industry, it allows us in this case to visualize how to increase the diagnostics of the treatment and the access to the treatment. We need to obtain the right diagnosis, the right treatment, and we're still facing some challenges. Just as a conclusion, I'd like to say that the main message that I want to transmit now is that intellectual property is very important in our system because the capacity that our healthcare system has must guarantee the access to medication. And they know that there's tight pricing and regulations. We have to use the resources we have. In the Colombian case, we haven't had a case in which there's a compulsory license process initiated. There's other measures in the systems items. There's pricing control via the judiciary powers or the federal administrator. We have to analyze the pathologies, the general pathologies, as the cases of hepatitis C. There's different tools that we have used, and there's intellectual property rights that we must consider in the Colombian healthcare system. Thank you very much. Thank you very much, Ms. Claudia. Doctor, it's been so interesting what you've just expressed in the first scheme. It leads us to be understanding more what's happening with intellectual property in our field when there's no generic medications, any drugs there that are of general use and are interest of the public. It's not just intellectual property in the industry. These elements correlate to the way in which we've built the healthcare system in Colombia and in social security. In our whole system network, we have to see which country can apply which strategies that's best to meet the needs and satisfy the demand. There should be pricing mechanisms to control price, strategic funds, pooling the procurement, and centralizing our actions that will lead us clearly to the proper coordination in our countries, drafting the right public policies. Right now, we're going to focus on how everything has to be, or it's manifest in a country such as Colombia. We're going to take this to a different level, an international global level. What happens with the waiver and intellectual property? What happens with the waivers amidst the pandemic when we're facing all COVID? How can we interpret the whole situation at an international scale? And in a national scale, I mean, it's global or national. Dr. Elise or Valentina Delich, we want you to express your bio briefly or introduce yourself. Doctora Valentina Delich has international law degree in Flags, Argentina. She works with different agencies, international bodies in the area specifically of intellectual property. She's working in Latin America. She's a representative of Flaxo, director. Thank you very much. You're welcome to the International Conference on Social Security. Thank you very much, Jorge Luis. For me, it's a pleasure to be here with you today. I thank you for having invited me, for the chairwoman of the conference for having invited me directly, Daisy Gonzalez Diaz. It's an honor for me to be present with you at this table. Jorge Luis, Jorge, it's a pleasure to meet you through these means. I had the opportunity to meet you in Buenos Aires when you're studying your master's, and then we found each other face to face in which we were discussing international property issues in various conferences in which we discussed intellectual property. So, well then, as it's been said, can you hear me? Can you hear me loud and clear? Yes? Perfect. Okay. Sometimes I see my telecommunications, my internet just go up and down, and I feel so much terror because I don't want to get a cut off of communication here. So, as it's been said by Jorge Luis, I will now talk about this subject at an international scale and macro scale. I focus on the level of debate or discussion of the initiatives that have been passed by India, South Africa, somehow they've passed these initiatives to try to suspend the exercise of the agreement or treaty of peak, or that draft or initiative that Miss Claudia explained prior very well. So I want to focus on the petition, the waiver, or the suspension of the trip or that other instrument or treaty that was explained. First of all, let me talk about the following. I like to speak of the dynamism of the tricks, not the negotiation stage that led us to that instrument, which is now part of history, but what happened to the exercise or the positive effect of the trips, I mean, in that law, because that document enables economies in development to ask for the rights in the treaties to take effect. As Dr. Claudia mentioned, the patent system and intellectual property in general is a balance and tripart. Three parties involved. One innovates, what makes this instrument very strong, and we have the rights to deal with the patents. Who has exclusive rights over the patent of a product, such as a medication? Think about having exclusive rights over medications. That means that there's no rival, no competition, but it's going to be possible for us to deal with monopolic prices, cartel activity with medications, because the production of of a medication is very important. I mean, there's tools and market instruments. This instrument, these laws or regulations foresee the exceptions and exclusions. Our system is a system that tries to maintain that balance because there's rights. There's rights that are exceptions. You have an exclusivity to exploit that molecule and continue developing your innovations, but it has to balance things off. There's the principle of fairness. There's mechanisms, there's agencies, there's bodies that constrain and limit also those guidelines. I mean, you can't just be limiting the access to the medication. We want to foster open room for innovation, for humanity's development, because that benefits humanity, right? Just to give you that macro scale of things. When La PIC or TRIPS or that document was positive in effect, I want to explain that the Patent Law Act, the Brand Law or Acts or copyrights are national in their scope. They're valid or in effect depending on time. Laws still apply at a national scope. Now, what happens? There's agreements, the LACIP or TRICS, it's an international treaty or agreement that establishes the minimum principles, the standard, the principles that our legislation in our nations cannot put aside. Those standards are extremely significant because of the type of laws and regulations that we have in our countries. If I tell you, it's a principle, it's a standard, okay? And that I can't in a country deny the use of a patent depending on the segment of technology that we're talking about. We think about principles and standards or the rules. I can't be part of any sector in the patent industry. India excluded food. India excluded pharma products, not the process, but the products. They excluded certain products. So based on an international signed of agreement, the norm is that the nation's legislation cannot discriminate due to the technological segment that sorts from. That's like a principle or a standard for some economies. That's how I want to explain the correlation of what's happening with international treaties or conventions because of the impact they have in the ways in which we build our relationships as nations. When La PIC came in effect in 1995 for developing or emerging economies, many of those principles were very high. I'll give you many examples. For example, the standard about the fact that the patent has a term of 20 years. Okay, La PIC in Argentina had a term of 10, 5, or 15 years, depending on what the petitioner asked for at the Ministry of Intellectual Property or Copyright. But in 5 years more of having a monopolic use of the product in the market gives us a term of 5 years. 5 years for that exclusivity, and then the generic molecules are open for the others. I mean, the international debate leads me to speak about the APIC that's in effect as an instrument in 95 for emerging economies. The emerging economies start implementing that law or act, and it's in effect. They compare the price before the La PIC as an instrument existed. Meanwhile, some developed economies, thought that those principles or standards in the document were too low. They had a list or a program, an agenda of amendments in their laws and regulations in copyright and patent law that were going to be thorough, more thorough than what had been happening in the international arena. And that came in effect. It was positive. The use was positive in 95. There was a extension of time for emerging economies that came to an end in 2005, 2000, and year 2000 for other countries. But by 95, this instrument, by 98, the international global agenda of intellectual property or copyright really had its disruption. There was a divergence there at an international scale with a World Trade Organization. That international trade organization is the one that administrates the use or drafted the TRIPS as an instrument with its essence that's taken to the World Trade Organization. Emerging economies back then in that time frame decided to go forward with their agenda. They wanted these global authorities with the international treaty to let the emerging economies use that instrument. And at an international scale, these economies wanted to ask these other authorities for more time, and they built another agenda. They had the TRIP Plus instrument. Doctoria Claudia mentioned it well. We signed up the trade agreement back then, and we had the TRIP as another instrument. What does this mean in that context? The emerging economies back then in that time wanted that instrument to be a bit more flexible, but at a regional scale, we had to resist the use of the instrument TRIP Plus versus what happened in other developed economies. We had a double agenda, double situations happening. We were debating at a global scale, international scale, and at a regional, local scale. We wanted to raise the bar with the standards and principles, and lower it on the other hand. So we had reached levels of great success in the trade agreements with the European Union, with the USA, that all of the standards and treaties have the TRIP 2 standards. We have a national plan. Us attorneys have a lot of work to do, trying to see what we're going to do at a national scale to have a full operation of those flexibilities in that law, to make them factual, to make them material, to make them tangible, depending on our capacity. So we wanted to use that instrument to benefit our countries. I think Miss Claudia also expressed that there's guidelines, and she was part of the initiative to draft the copyright and patent laws there in Colombia. If this instrument, La TRIP, allows us under discretion to really establish our nations, the initiatives for the patents of medications, we can, as examiners, determine and fix a price with certain characteristics that's being used in the industry. We have to establish the standards, the provisions that are strict when it comes to patents. If a product is new, old, it's a major task, and we were all called into as nations in development to draft this. Some countries, such as Argentina, we have to see how to use a medication. We can use it double or for another purpose. A medication that's used for a condition could be used for another condition. There could be a patent or not, but in Argentina, it's something that it's compulsory. So using a medication for a second purpose is something compulsory. So making the law object of interpretation to see how it applies to the industry in a very restrictive way. So that's the full landscape or scope of what happened with TRIPS, that instrument, which was created in 95 or in effect back then. How did it go for us when back then we were dealing with a multilateral agenda, trying to minimize TRIP plus in the treaties, the free trade agreements, the regional agreements, bilateral agreements, plus our national agenda. We wanted to take all of these instruments into exercise and the TRIPS left certain doors open at an international scale. And as Ms. Claudia mentioned, our great success was the Doha Declaration that was done in year 2001. That was a declaration admitted by the conference in a conference in 2001 by the trade organization, that body. We should have another workshop to study how it was drafted, how the Doha Declaration was drafted as an initiative back then. And then, as based on our experience, we can use that past experience amidst this present in the pandemic. There's cases of great success, such as Brazil, South Africa, like the like India too, cases of success. In any scenario, the Declaration of Doha lays the grounds of a multilateral positive effect. In Doha Declaration, we have criteria to interpret international treaties and conventions, confirming that the TRIPS instrument cannot be interpreted to obstruct the drafting of public policies in the healthcare system. The TRIPS is part of the Doha Declaration, is the instrument that opens the grounds to the and room for lobbying and debate. As Dr. Claudia explained, one of the mechanisms that we have to deal with emergency crises, that we're facing, one of the mechanisms that we have are a compulsory license. And when I say compulsory, the owner of a patent has to share his or her as an entity its creation. The compulsory license decree, as we've said before, our laws apply in the territory. When I trigger the use of the compulsory license, it's valid in my territory, and it has to be used properly in my territory. It cannot be used by another territory, because in that other territory, they don't have that in their provisions to trigger the compulsory license to use that product without the will of the source. And it leads me to say, who can use a compulsory license here? Who can use it, take it in action, exercise it in any of its version? You can say version A, it could be the private subject. B, it could be the government as a stakeholder for public interest and use, who has infrastructure. Who doesn't have the infrastructure in their territory to manufacture the medication? There, somebody that has the infrastructure can, who doesn't, can't use that instrument. It's an instrument that's part, annexed to an international treaty or agreement, but in effect, or positive law, doesn't let other countries use it who are emerging economies. So in the Doha Declaration, there was a successful debate for the amendment on TRIPS as an instrument, because those countries that don't have the infrastructure to produce medication can trigger the use of compulsory license and ask another country that does have the infrastructure to produce and export. So for me, that is in general the way in which we've won the case regarding the Doha Declaration there. So, amidst the pandemic, when the pandemic started, when COVID-19 happened, I'd say that it in the past 19 years, I mean, before COVID-19, the emerging economies had been working on studying the TRIPS. Everything's documented, everything's studied, examined. Some of elements are used and taken to exercise. We're tired of the debates that have taken place about the compulsory license, the types of licenses. So much debate has taken place amidst the law and COVID. So I think the COVID pandemic seems to be something minor. 10 years ago, we were talking about the malaria compulsory license, a list or a roster of conditions and diseases. And we had a list, okay, what do we have, or which elements or criteria should we consider to declare something as a pandemic or not? I mean, it was March 19th when we declared the emergency and crisis globally of the pandemic. So what happened with all the international infrastructure architecture that regulates one of the mechanisms that foster innovation? We as humanity must innovate. There's limitations, there's constraints towards that access. Many of you know this. And basically, the countries cooperated just a little bit. More than cooperation, it was competition. They didn't reach agreements, and I'm talking about the economies that were present. They couldn't build a response. An instrument is a response. The economies just went out to these debates to try to obtain and satisfy their need, the procurement of vaccines. I mean, when we think about vaccines that were still in the phase of trial amidst the pandemic, on one hand, the entities started investing, allocating budget for a fortune to develop a vaccine. And that's not very usual, right? Usually, the investment of developed countries happens from the private sector more than the public sector for to develop a pharma product. That's what we have in research in the pharma industry for development. The states, the nations invested millions and millions of dollars on developing the vaccine. There were partnerships, there were allies between the pharma industry, huge companies, and other companies that were smaller but working on innovation. So the type of partnerships amidst this time, or the alliance created between huge pharma companies that really know about how to work with the scalability of the production of a product, they created relationships, bonds with smaller companies or SMEs that innovate or innovated to develop the vaccine for COVID-19. AstraZeneca, the University of Oxford, which all of these entities have the know-how to develop the vaccine. Pfizer with biotech, that's the small company that has the know-how, the innovation. So these partnerships have been huge. We're talking about small and medium-sized enterprises and huge global companies. Small and SMEs, I mean small in comparison with global companies that have complete technology. They have a whole network of instruments to be used to develop vaccines. But basically, what we were analyzing was the international infrastructure for the economies or nations to cooperate didn't function for us. The companies didn't trigger their compulsory licenses, even if the pandemic had been declared for 9 months because of what Claudia said. You know, it's not just that a compulsory license will solve in short term a pandemic in 6 years, a year, or a year and a half. The mechanisms or the triggered license, which is compulsory, takes its time. There's a term. Nobody used the compulsory licenses. The countries built their own strategies on their time. Simultaneous actions took place, but they didn't cooperate. Nations didn't cooperate. They guaranteed the access of vaccines, signing off agreements to binding contracts to obtain vaccination, contractually speaking. We had to trigger the mechanisms to obtain the capacity to trigger a compulsory license. The parties involved declared as economies the emergency of the pandemic. If some didn't have the instruments or the mechanisms to trigger the compulsory licenses, they created them like that. So there was one country that triggered the compulsory license, which is Israel. At the beginning of the pandemic, they triggered the compulsory license petition before a medication that was required to lessen or lower the effects of COVID as a disease. Now, and they created the patent holder in the lab, in the institute, the agency that was part of it, with complete will and intent, gave that formula or access to the government without having the need to use the compulsory license. Of course, there were some voluntary mechanisms. There were companies that decided to also share industrial layouts, designs, and the know-how of the devices, that the concentrators, the oxygen, I don't find the word, the units that provide oxygen to the subjects suffering the condition, the Yesenia, okay, what, thank you very much. The units that provide oxygen to the subject. So some companies had an initiative and they had the will, and their initiative was positive. They gave what they had to give. There wasn't a need for an international steering leading committee that to ordain amidst the pandemic what had to be done. In that timeline, at an international level, Brazil, South Africa, and India during October of last year stated that a solution could be the suspension or the waive off of rights that are found enshrined in the TRIPS. So back then, these countries asked for the suspension of Chapter 5 of TRIPS as an instrument. That's the patent chapter. I could decide not to respect that chapter in the TRIPS, and I could use the patent without the authorization nor economic benefit. Number two, copyright was overwritten. I mean, there is industrial design, number 4, and section number 7, that's secrecy or unveiling information in that chapter. That's preclinical trials or preclinical clinical data that's in a protocol submitted to agencies that regulate pharma. So with the TRIPS, they said, okay, suspend rights at this time so countries can start their own production of the vaccine, not only the vaccine, but correlatable technologies required to produce the medication in a preventive measure or cautionary measure to avoid having issues. We will avoid, and they would have more production, more locations to produce the medications, and more access as a result. So basically, the nations asked to free or release all the production for the vaccine in law. The personal protection equipment was also part of that cause. What the nations involved petitioned was for that term to extend to 3 years and object of a renewal under close tracking and monitoring. So each nation decided to study the progress. What did the international community do amidst the pandemic? International community simply divided. Emerging developed economies in majority supported the waiver regarding the TRIPS as an instrument, and the rest of the countries were very divided. Europe itself is very divided in its territory. Germany is a firm defendant of the TRIPS as an instrument. It should not be suspended. France and Italy are have more empathy. They want to open the TRIPS for its use. European Union includes other actors. When you think about actions of parliament, you see about the small lines. There's no unanimous actions in acts of parliament. The commission that works to innovate, the commission that works in the healthcare segment. These commissions constituted could not write declarations because they could not have the declaration under consensus and vote to cast their vote. In acts of parliament, there was an expressed instrument in which they stated that the United Nations should support that. But the acts of parliament are only one part of the system in the European Union. Where's the general head or the chairwoman of the commerce global entity that was appointed her for her position in August amidst the pandemic? This chairwoman could articulate an organized response with regards to the health
to the health patents and the access. So she is from Nigeria and has worked in Gavi. It's a fund that buy vaccines in order to try that developing countries have more access, but it is not clear that she, as director of OMC, promotes that TRIPS is suspended. And one of the great surprises was Biden when he won the elections in USA, because surprisingly declared that the United States was supporting the discussion about TRIPS waiver. And then after a lot of debate was provoked in USA, it restricted a little bit the Biden support. And he said that he supported the TRIPS waiver while they produce vaccines, but not to the rest of drugs or prevention drugs, only to vaccines. And even though you can ask yourself, well, and that support is visible due to the warm look of Europe. But the laboratories discovered that most of those producing, except Moderna, have all a partner from Europe. So the situation is far to be solved. formally next November. All ministers in ONC will gather. The topic will be on the table, and we will see if TRIPS is suspended or not. And to wrap up my presentation, I want to tell you what will be the waiver effect. Beyond that, we see that in principle, you can say you can use freely the information of a patent without asking authorization or remuneration, as TRIPS says. But I want to tell you that that is not enough, because the distance between the information enclosing the patent and what you need to produce a drug is much more, and includes knowledge and information that are also covered by other intellectual property forms, or are even without any intellectual property. For example, commercial secrets and non-disclosed information, what we know, the inherent information, we call explicit information and knowledge, what is of open domain, the one that is there. And many people that do processes are secret and think even the easiest things that you do. If you buy a product and you install it and operate it, you ask technicians to come from their origin and come and transfer all your knowledge and all the know-how that is linked to the correct use of that machine. And that is not only the technology transfer, but also patent information, commercial secrets, and untangible secrets, and that is non-disclosed. All the specific points of the operation of the product and scaling vaccine production of all the relevant information that you submitted to be regulated is in the hands of the company, and it is not in the form of patents. So you can say the waiver, yes, I agree on the TRIPS waiver. And personally, I think that because that it's a political message, and in the broader sense, but we are in the pandemic and we cannot restrict the possibility of producing the vaccines in all the places, because the vaccine is needed in all the countries. But that doesn't go to the operation per se, but it's a mission of values. Where do we want to go in the reconstruction of the world? And that we will have to do. And we will have to see that there was a lack of coordination between the WHO, ILO, the G20, that is the cream of the top of international organizations. There are many proposals on many topics on how to solve this problem effectively beyond the TRIPS waiver. And there are some very interesting that go, for example, on how to deal with supply, offer, distribution, and finance of the production of vaccines. Well, then this is my presentation. I wanted to give a general overview, and I hope that I have not depressed you with this international panorama. But if you see it, aware that humankind is living a pandemic, and that even that I admire this international architecture because I am an international lawyer, we haven't been able to use it to strengthen the production and the access to vaccines. Thank you very much. Thank you very much, Doctor. It was an excellent summary. What is the situation that we are living nowadays? And it is very important considering that Latin America hasn't been able to develop innovation to say that it has its own vaccines. And that is something important. It's our debt. And there is an influence of the international treaties and also an influence of the free trade agreements. Because now, as Latin America, with the exception of Cuba, doesn't have any vaccines in the late stage. And what has been the role of intellectual property? We talked with some experts on distribution and access to drugs, and they said we distribute and we import many drugs because we don't have the production capacity, even though we have signed free trade agreements that state that after signing the treaty, and they were going to transfer technology, but why not? Why the health sectors have to face these questions? For example, to import drugs at a high price that are protected by patents. So these are some things that we have to think and consider from the public policy sector and essentially from the scope of Latin America. And this is very important because we have many factors that united us instead of separating us. And then we will see how this public policy topic related to the international access of drugs, how is put on the table of negotiation, and how institutions are facing this, and how the countries, for example, two countries as an example, are facing the drug access, not only for vaccines, but for many drugs. And now I will give the floor to Dr. Yesenia. Of course, I will give a brief bio of her studies. Now, Dr. Yesenia Diaz Medinas is Doctor of Medicine, graduated from Santo Domingo University. She is a family and community doctor, clinic doctor, and has a master in health management system and PhD in development of sanitary technologies and estimation of cost of health sector. Nowadays, she is studying the Master of Health and Drugs in the University of Spain and public policies. And also she is designing policies for the sanitary institution in Argentina. She performs the health sector role for contributive plans of the labor and labor risk superintendents in Argentina since many years ago. She has the experience of health management and social management systems. So Dr. Yesenia, welcome to the Inter-American Conference of Social Security Studies. Thank you very much, and thank you to all the panelists. It's a great pleasure to be able to share with you some experiences from the family health insurance and from the social security sector and the access to drugs. Well, all the lectures have been very important, and I want to tell you that drugs have a high impact on the health expenditure. And in the last 30 years, we have seen how this health expenditure has increased. In the same way, we see how the health increase have been impacted worldwide, generating an increase almost of 100% from 1990 to 2018 in the GDP of each of the worldwide countries. And in the same way, the drugs are linked to this increase in the drug expenditure. It is linked for the higher use and the new innovations, as my colleagues have said. Also, the new generations are consuming more drugs. And this is an important context to be able to say how the national health systems and how Dominican health and social security system can face or cannot face the expenditure, how it can face the challenges to guarantee all these in public health sector. I will be talking about this in 20 minutes, but I need to tell you that in the Dominican health national system, we are ruled by two means that comes from the Constitution of the Republic, the Article 60, and the law number 8701 that creates the Dominican system of social health and the social law. In the framework of these two laws, we have the national health system and the Dominican social security system that run parallelly with two regulations in spite of the national health system that rules the public policies for health. And in the social security, we have the National Council of Social Security as the ruler of this system. The Dominican social security system is constituted by different institutions, among them the labor institution that rules the social security and where we are working in and takes care of the fiscalization, control, and ensuring and financing of the health sector. And also there are three financing regimes: the contributive, that is the subsidized by the government of our country, and also it tries to cover health and have a 100% universal health coverage of all the population in the country. In relation to drugs, we have two decrees that rule the access to drugs. And the decree 24606 regulates the fabrication, elaboration, quality, supply, circulation, distribution, and storage of the drugs. And decree 66512 that establishes the description, prescription of drugs in the Dominican health sector. From these regulations, we see how the access to drugs is generalized both in public and private sectors and in the hospital and ambulatory system. In this sense, there are different mechanisms in both sectors and in both arenas. For example, in the hospital and in the ambulatory sector, for managing the purchases, we have to be ruled by demand. The purchase of drugs depends on demand. In the hospital public sector, we have the unique management system of drugs, that is SUKIN, and the purchase is done by most of it by an institution that is called Prosecal, that takes care of centralizing the purchases of all drugs for the public sector. In the hospitals, all the purchases are directly and they can be done especially. In the case of drugs for HIV or of high price, both can purchase through direct purchases and through joint purchase mechanisms. And also we have to say that in relation to distribution in the hospitals of public sector, both the public hospitals and the high cost drugs issued by the Ministry of Health. In the private sector for hospitals, we have direct purchases from laboratories or directly from pharmaceutical distributors, and the distribution is done through clinical centers and through high-cost clinics. So now I will explain how in the ambulatory sector we can see that purchases are done in the private market by specialties and how it is distributed through the private pharmacies network. In relation to financing, well, we will see the relationship of the financing regimes, both in the subsidized regime and the contributive regime, or the next health plans, including the retirement fund and the retired employees. And also besides the labor risk insurance financing that guarantee the access of drugs of low financing clinics, and also the labor risk insurance, we have the American Institute of Labor Risks, and they protect this kind of people from these kind of risks. In relation to coverage for insurances, well, we have in our country almost 10 million people affiliated to insurances, and 93% out of them is affiliated to the national health insurance system. In relation to the family health insurance, the national distribution was until the end of last year practically preponderantly in contributive regimes. But last year, there was an affiliation of almost 2 million people in the subsidized regime. And therefore, now we see a change in relation of the population of distribution. Many of the people now are affiliated to the subsidized regime now. It is important to emphasize that inside those plans, of health insurance, we have those of retired employees. And now we dedicate care to this population, and there are 93,692 affiliated people, and reaching a coverage of affiliation of 94.3% of the population. I also want to tell you that financing drugs in the family health insurance will depend on the economic contribution done by the state and, of course, by the employees. In the case of subsidized regime financed totally by the state, based on the current per capita is 388 pesos with 32 cents, more or less $4. In the contributive regime, this contribution is of 1,167.81. And I have to say that this is above almost 5 times more the subsidized regime. And also in the subsidized regime, there is an additional contribution done by historical contribution for hospital that covers the finance and coverage of drugs and other services. Also, in the case of the contributive regime, it has been amended, and also the health plan has been amended that includes a specific list of drugs. And particularly speaking, we had experience some years ago with this resolution 375/12 in 2012, where there was an increase of coverage in that year, covering from 3,000 to 8,000 the drugs for ambulatory patients. But the increase of this coverage generated an increase of prices into the drugs. Of course, we improved the access at that time, but we were able to see very effectively that one of the negative impacts of increasing the price based on a control price policy was the reduction of access of drugs by in some part of the population. I want to share some macroeconomic information in order to have access to drugs. The Dominican Republic, as in other countries in the world, has been increasing the GDP per capita in relation to what we can see in the graph in terms of the purchasing power. And so see right now, compared with other countries, our per capita GDP is in 15,209, and also see the increase gradually since 1991, and in 2020 we see a slight decrease, and it affects the pandemic, particularly this decrease due to the decrease of family revenues. In relation to total expenditure of public health versus private, it has been increasing sustainably in Dominican Republic with a greater participation of the private sector. However, from 2011 to 2012, there was more participation of the public sector. Of course, we know that the evolution of the health inflation is important because it affects the health expenditure. However, at the level of the Dominican Republic, it has been gradually sustained in the last years. Something important to mention is how people access, how the affiliated people access to drugs through the Dominican system of Social Security. In the case of the contributed regime, at the hospital level, The labor health administrators guarantee 100% of drugs, unlimited. All the drugs that are needed have been distributed by it, with the exception that they have to be prescribed in the list. And the affiliated has to pay a difference for all the set of drugs, $460.35. That is the maximum it has to pay for every time it goes to hospital. The important point is that it is not limited to the fringe benefits catalog in the hospital, but in the ambulatory regime, it is restricted. It is within a specific list with a coverage of 70% of the insurance entity and the rest for the affiliated, and it has to pay $139.86. In the case of drug coverage for cancer, we have an annual coverage of drugs of 1 million pesos, around $17,482.52. And both has to have to include all the drugs in the list. The laboral risk insurance covers all the drugs at 100%, unlimited. But it has to be qualified in the list. In the case of subsidized regime, all the drugs are covered, both at hospital level and ambulatory level. However, you need to remember that that depends on the national purchase of drugs done by PROMES, and in the ambulatory regime, it is distributed by primary healthcare centers, and the coverage is at 100%. In relation to the total health expenditure, we have seen how it has increased at the level of people in the last years. Here we see a graph where you can see the last 3 years. However, as you can see, from 2018 to 2020, we see a slight decrease in terms of drugs expenditure. If you can see differentially between the contributed and the subsidized regime, you can see that in the contributed regime, the expenditure on drugs has continued to increase. And this decrease that was seen before, well, it depended on the reduce of almost 50% in the subsidized regime. Please see that we are talking about expenditure, about the investment done by the health administrators, but that is not necessarily translated by the investment done by the state based on historical budgets. And in the year 2020, we understand that this is due to many causes. Among them, the determination, the decrease of health demand of that year, where we declare the national emergency, the specification of some center as COVID center specifically, and the lack of care of some chronic non-transmittable or non-communicable diseases programs. And in the same way, we can see how in the evolution, the prices paid to drugs in the ambulatory versus hospital centers. And from 2012 to 2015, there was an important increase. But as from 2017, it begins to decrease, that investment done by the family and health insurance in relation to drugs. And of course, it is not a decrease of investment, but restrictions to access. And specifically, it is due to the medical prescription that maybe is concentrating in the last years on drugs that are out of the list of drugs authorized by the Social Security. That's why for us it is very important to show to you this graph where it is reflected how the expenditure to drugs is distributed in relation to the bucket purchase. That nowadays is in 55.5%, and out of it, 68% is due to drugs. Well, we have had some experiences for savings generated by centralized purchases. Among them, in 2016, we had an epidemic of Zika nationwide, and also it replicated in many other countries. Dominican Republic was affected by it, and the Barré-Gilead syndrome due to Zika virus was needed to be cured. And therefore, we saw 1,556 cases approximately. Analyzing the investment that the Dominican social security system needed to do to cover all the care of the syndrome Guillain-Barré and give the drugs, we saw that based on the access to health services, people with Guillain-Barré syndrome needed to go to intensive care unit. And in these units with limited coverage, it was 17 million pesos. And only the drugs for these cases will be consuming 80 or 90% of that service or of that financial
Llevó a que la Superintendencia de Salud y Riesgos Laborales, junto con el Ministerio de Salud Pública, pues establecieran un mecanismo de garantía de acceso a los
Republic guaranteed an access to drugs, as for example, Milinumab, and allowing that the health centers will finance this access to drugs through the high-cost drugs program. The difference in prices was very important. As we can see, the price of human hemoglobin in the local market of $62, while it was purchased through the public health sector through high price was of $72 approximately. That meant a saving of $6,741,000 for affiliated people, not necessarily for the Social Security Dominican system. And so that money needed to be paid by affiliated if they will not be identified the mechanisms that solve this situation. Right now, we are doing some proposals to improve the access to drugs, taking into advantage different mechanisms that take into consideration the care and management health systems and the financing systems. We had 22 pathologies done in the country, and we were able to see and compare the drugs available in the high cost program of the public health sector.
For these 22 pathologies, only 21 are common. 40 some. I mean, we have 36 drugs in the catalog, but we should include 30 extra drugs in the Dominican system on Social Security to comply with these 22 patents. What's important out of this is the following. When we analyze the pricing in the market and the pricing of the Ministry of Public Health, the prices with which it could go through a procurement process as a country, I mean, only out of these three pathologies does the market have the capacity to price the drug at a lower price with the Ministry of Health. And if the country decided to obtain those high cost medications, high pricing there, they could decide to take an option through the Ministry of Public Healthcare. We could save 28% in the procurement, but if we use the economic option for those other 60-some pathologies, we could like work with a market price that was cheaper, and our saving could be 29%. Now, in the case of drugs amidst the pandemic, we've had a very interesting experience. In the case of certain medication, we had to build a different type of method to authorize the digital prescriptions of these drugs. We had to increase the delivery of household delivery for drug medication. The government, through the healthcare institutions, delivered to the beneficiaries the medications under a subsidy scheme. The government has guaranteed a very important financial investment from its budget to sustain the expenditure to treat and manage COVID-19, starting with a PCR lab test, guaranteeing the use of these tests in an unlimited case for the family insurance in the healthcare system, and they ensured they'd have it for all the population. This is what we had to do in 2021. The coverage of what we've obtained is limited to one a year, but the budgeting of it is still preserved. We pay for the PCR test, state funding till December 2021. It required an investment of $116 million to give coverage. We had to spend $18.5 million during the first months of the year until December. We had to use that for personal protection equipment, and the members paid their fee, and the healthcare risk agencies had to take on the economic load. And we broadened the coverage to other communities in our location. It's important for us to mention this because there is an incremental access to medications. So speaking specifically about remdesivir. Remdesivir is a molecule that has had certain impact in during COVID-19. It's been used, and there's the basic plan or an instrument, and it's not under the coverage of the Inter-American system on Social Security. However, there's no subsidy, but there's an agreement created between the Ministry of Public Health and another agency providing the medications and the resources. We had to draft the financing mechanisms or with the healthcare risks agencies, and 14 authorized distributors of ARS were approved to ensure the safety of the medications that were offered. There was a bid in the pricing of remdesivir, establishing a fixed price, offering like a 60% decrease in their cost for our system. Of course, the authorization of the use of these medications, it's subject to the approval of the medical protocols or the protocols that were approved by the ministry along with its budgeting. Now, this has been the graph in which we show the evolution in the graph of remdesivir. During June, we had great consumption of it due to the pandemic peaks in the spread. So we've invested close to $9.5 million to date, to this present, which has benefited over 7,000 people. Specifically, the retrovirals here and the access to these lead me to say that they're not financed by the Social Security agencies, but by subsidy of the state. It's a procurement process that's centralized. We have proposal to budget the procurement through the Family Institute here, which will be the agency financing the procurement of these medications in the public health family insurance entity as part of our system. We have also gaps which are important when we speak of access to medications. You can visualize there's a critical roadmap, and there's some gaps that have to be narrowed critically. The coverage is a point. The government has its regime or scheme for subsidy, and we have the subsidy of 50/30 that's substantiated and specified in law. And there's fees or contributions. The sufficiency of or lack of supply has been seen or has been a reality between like countries. We have an absence of public policies to buy or go through a procurement process of generic medications. We know that there is a lack of response or services being offered with immunization and other conditions like malaria, tuberculosis. I mean, we've been limited, and we're trying to guarantee the existence of the medications for the vulnerable populations in our segments. There is a lot of information that currently exists between the ARS and the members, beneficiaries, and other agencies. There's been some limitations that are regulated by our guideline 662. That's still an instrument object of amendment. It's still pending. Amidst this, we are facing challenges to improve the access to all of the aforementioned under conditions of sustainability. So we're trying to broaden or increment the capacity to operate in our clinical support systems. We want the clinical case files there to go through a decision-making process. We have to select the medications in a scheme that makes it all sustainable for our people's well-being and go through the proper profile and economic assessment. We've also analyzed this with the pharma industry and the shared risks for the healthcare sector. We've guaranteed the fact that we've adhered the prescriptions to other instruments, which are protocols. We have built partnerships between stakeholders in the public and private sector that can improve the procurement process of medications. And we have been working on trying to facilitate the investment or the expenditure allocated for these purposes. We have drafted public policies to go through the process of medication procurement here in a joint ventures. Somehow, the pharma industry has had an important participation when guaranteeing the efficacy of medications at a lower cost. When we petition its technical specification sheets and the approval from the regulators in our nation, from the regulator, they receive that approval. That's extremely important for us. We're trying to do our job the best way possible to trying to reduce at the same time that pocket expenditure from our people from a 68%. We're trying to make a decline because it's the Inter-American Social Security entity that should also be working with the administration of the benefits or services offered in the healthcare systems. We have data being published, a lot of analysis happening. You can have access to the website here with our links. We have to analyze the coverage of the Inter-American system and the availability of the services that it offers here in the basic plan. And in case you need pricing references through this website, you can access to a matrix of data to obtain the information. We thank you for being present. Thank you for letting me share my presentation today. We're here to serve you, and thank you for communicating with me if you have any questions. Thank you very much, Yesenia. In this case, thanks for your presentation. It's been very succinct, and for the sake of time, I can focus on the access to medication as a specific issue. There's policies drafted for innovation, market control, pricing control, quality control. What we're doing will have a direct impact in our country. So we're going to have to try to understand that it's an holistic approach. There's many points to tackle, many elements to consider. We have to treat the matters accordingly. When this is critical, and if we don't do things right, there could be a lack of balance in what we obtain. And we have to be efficient. We have to understand the tools and instruments in hand and the areas of flexibility that lead us to guarantee our people's access to medication. We're talking about access to healthcare systems, access to the medication, but we don't even know how much it costs, nor what it means to have medications be present in America. So that's a point. And it's a point that we need to discuss in the inter-American system. There's lack of fairness, there's vulnerable groups in all our nations, in all our vulnerable minorities there. We're not just focusing on one point. Usually economists in their field focus on one area and anthropologists will focus on another area. We in our area have submitted or issued a ruling a sentence from Dr. Elsie. For us, a ruling is very interesting, not only in the judicial field of things or in what's lawful. It seems to be very interesting. We analyze how the Equatorian Inter-American system works and how can we, as parties, guarantee under the mandate of our laws for our people. We have to work for our people to have access to the medication. In this webinar, we've discussed public policies, the reality that our institutions and agencies are suffering, and how could we, from the legislative branch or the judicial powers, well, materialize this. We have the keynote speaker with us today, and one of our panel members participated after being accredited as a passive subject during a moment. Dr. Duran was working at a national level as one of the health elements that deals in the healthcare ministry. As a part of the regulator in your country, we expect you to tell us what's happened in your nation with your court rulings. How does this make tangible or materialize the case of access to medication? She's a keynote speaker, so please, doctor, I'll introduce you briefly. Dr. Esli Duran Cuesta, she is a chemist, expert in pharmaceutical, master's in public health care. She coordinates the supply of medications at an individual family level in Ecuador, national director of medications and medical equipment for the healthcare sector. She is the chairwoman of different tiers of drug suppliers in the healthcare system. She's a scholar invited by many universities, from the Catholic University in Ecuador, the Loja University, the Andes University. She's also been a very important keynote speaker in national and international conferences. Ma'am, you're welcome to the Inter-American Conference on Social Security. The floor is yours. Thank you very much, Jorge. Thank you very much. I'd like to thank everyone for sharing their knowledge. Thanks to the rest of our panel members, because what we've heard is an exposed reality of what's happening in different economies and different fields. I'll speak about what's happening because a pharma case led us to issue a ruling, a court ruling, but the substantiation of the court ruling at some point will be read by some of you. Jorge, I hope you share that court ruling from our tribunal. In that ruling, you're going to have a structure in which you will find all the criteria that guarantees the rights to access health, public health. And within the point in the ruling, you have a segment of access to medication. Just to give you an example, and as many other examples in Latin American countries, we have a lot of lawsuits because in our courts and tribunals, because there's medications that our people need to have access to, and there's a basic list of medications used by our people. There's a strategy to select a list of medications which are considered essential. The list of essential medications are an instrument that guarantee the procurement and the acquisition of instruments of or medications, because that's the way it's structured in a country in this network. And the institutions in the healthcare field, such as an insurance agency or company that I'm working with or part of, we provide public healthcare systems. In the agency I'm with, we provide under the principle of universality, in our charter and constitution mandates us to provide coverage of schemes correlated to financing capacities, which is the responsibility of the state, which from the public healthcare grounds, they have to, as a government, develop our people with well-being. And in our constitution, in the body of our constitution, we're working all for the well-being of our citizenship. Amidst the context, we have a charter that guarantees the rights of our people, and then there's other segments of the constitution that don't guarantee other rights, like universal access for an agency that's the insuring stakeholder or other ministries or bodies involved. What happens in this ruling, court ruling, there's many lawsuits, as I've said, because people haven't had access to medications that were out of the roster or list of essential medications. Our nation has a method, the exception court proceeding that's based on themes such as sanitary healthcare technologies that need to be used to provide full coverage of the services offered in the network that works for our people's well-being and health. Our patients could be sent to a third party to use private services, which have by mandate, and it makes it compulsory to provide to the patients the essential medications in our list or matrix of medications to guarantee access to them and safekeep the principle and the right of universal access without discriminating any person. How do we guarantee access according to the criteria of quality, efficacy, and safety, which are established and enshrined in our Constitution as part of our fundamental rights? If we understand these three concepts, three words, these three words are complex. We faced many cases were filed against the court because judges were ruling that if there's a lack of medication and who is prescribing the medication is not, there was the patients, the victims usually won the cases. Why do we delay an IT technology analysis in this field? An analysis in the IT world cannot take us only 24 hours. It depends. I mean, we need to pick or obtain the best bulk evidence to study and analyze the technologies that are part of the case. We have to understand the complexity that underlies in the context and analyze the patient, the subjects involved, the parties. These cases were difficult to just be heard in a public hearing at our courts and it was difficult because we needed to comprehend both parties by the triers of fact that were having these people at the bench in a public hearing. I mean, there were other court hearings that took place because there was the plaintiff. We were the prosecutor, or we are the Ministry of Health, right? As a party. And our representative was the regulator, the authorities, or the health ministry that has to deal with all the documented policies that lead us to discuss access in the case. And there were trials ongoing with our patients. Meanwhile, there were kids in years in which they require pediatric services and they weren't being provided. Imagine the cases of each patient of subject. And we didn't want to have false expectations with regards to the resolutions of the patient's pathologies in the cases that I'm talking about, when there's diseases that lead us to a catastrophe, such as inherited conditions, strange or decisions or pathologies that have impacted our people's health. So there were a lot of emotions being ventilated as testimonies when at the courthouse, when patients and gave their testimony under examination or cross-examinations. We have to think about the strong points, and the guaranteeing party of the services is the public health care ministry. There's scarcity of resources. Resources are never enough. Budget never gives full coverage for our people's health. We want to build strategies to have our people have access to the services, but we never satisfy 100% of the needs. Thinking about our budget, right? The resources we have to weigh things, ponder things. There's a balance. We have to keep that balance. There's catastrophic inherited conditions and other diseases that are acute or chronic diseases that are not transmitted. We had to analyze all of this and create a fair grounds balance and have patients really have access to medications. There's millions of dollars that are allocated, and the person that requires the service, the patient, should comply with three criteria specifically established in our constitutional rights. We needed to work this out under the principle of fairness, that justice the magistrate that was in charge of this constitutional ruling obtained data through these court hearings during the requirements and the use of resources at courtrooms, because we needed to correlate a lot of evidence and information with international examiner reports. So in such a way, we were capable of building in the body of the constitutional sentence a PhD level, a dissertation. There's in this resolution, you can analyze the guarantees of the lack of infringement of our people's rights, the ministries of health, and the parties involved. You have the express criteria in the ruling. So please help me with the first slide. In the first slide, you can see this ruling, as I've said, that was issued in August 2020. You see, in this sentence, we wanted to guarantee constitutional rights enshrined in Article 32, which gives us the right to health, and 336 to guarantee, in which we guarantee the access to medication to efficacy medications that are top quality and the efficacy of them is proven. There's a segment in this ruling of availability. We annexed. There's an addendum to this court ruling, and we added other medication to the essential medication list that we had. However, there's public policy in place, initiatives, but back then we wanted what's procedural to stop backlogs. We needed to give it the right dynamism to meet the needs and satisfy the needs of the patients. As I've said, having access to medication. In our constitution, we can read, you cannot discriminate people who because they're marginalized, vulnerable. You can't discriminate them because of economic issues such as pricing, the availability of medications. We have to have this materialized. We're talking about tangible situations in Ecuador. We need as a country to have the resources to pay it. It's part of the access and availability. Our system that works for health of our people has to have the capacity to finance the product to offer them to satisfy the needs of the beneficiary. We need to provide the necessary data to make sure that we have access on security grounds to access of quality medication. Thank you very much. Next slide, please. Jorge, could you please help me with the next slide? Amidst the context, the access to medication that we faced was branched out into three situations. There are people that there were medications that were part of the essential lists of our nation that are considered, as I've said, essential. It's written as a matrix through the steering council from the Ministry of Health that has a constituted commission that analyzes the medical equipment required along with the medications. That commission creates the essential list based on evidence, on findings. What was the problem back then in the time frame? To give you context, we had to review that instrument for the 9th time. That instrument was going to be in effect for a term of 4 years. Now, the claims are the following. The review process of this list of instruments had to be amended, had to be adjusted, because there were not, there was a specific need to review it, update it, amend it in a specific term because of the characteristics of the epidemic conditions of our country. So we had as a nation to go through the assessment of that list. Making this list or this situation was a constraint, a limitation. That matrix of products had to be analyzed or reviewed every 2 years. It's important after all the debate and all the analytical efforts in the Constitutional Court. The Constitutional Court, after hearing, modified this and transformed this instrument in which it established the position of the counterpart. If we have a list of essential medications, object of the review of the court, the medication in the list should be available through the public healthcare system, ensuring quality and efficacy and availability. There's another counterpart list that is a list of products that are not accessible for the people. in the list. So we had the both sides of the story. That list was not accepted as an essential list. It cannot be accepted by any other reason of exclusion, nor through the use of the resources in the judiciary branch, now in the power, in the authority. So these provisions or the court ruling, the National Supreme Court specified in the ruling the list of what subjects can have access to and what they can't have access to because of the principles of quality, efficacy, and safety. There's the procedural resources. The ministry's agreement 162A is in effect. There's an amendment in it through the agreement 321, and the Ministry of Health has to establish the procedural side of things in court proceedings. Everything should be agile, efficient. All our laws and regulations should lead us to satisfy a need timely for the patients because they demand the use of medications that are not in a list. But there might be exceptions to the ruling. Two criteria exist. I mean, there's a process of assessment of certain technologies in the list, and there's other products being used because of the emergent conditions. Do we need the substantiation or a prescription from a physician, a certified physician, for the courts or the authorities to know that the patient without the medication is at risk? If you meet those two criteria as a subject, you can have access to those medications. But the trier of fact thought about amending the public policy, an amendment in the public policy to make the conditions agile for other situations that just simply happen to have happened there. So we went through a critical analysis about the medications that are considered in these trials. Some experts had to go through a protocol analysis where they had to study the sentence, the medications in the list, the economic impact that it had. And within these court hearings, the court admitted or obtained the testimony when they called the examiners to the bench to give their information as examiners in their report or deposition. Now, who prescribed a medication might have had a situation of conflict of interest. Who prescribed a medication might not have had thorough analysis of the object that was critical to understand in the medical field. The medications had to be safe, top quality, and in compliance with efficacy. There was a prohibition. Somebody in this process, an object was banned or a situation was banned. I mean, the medications had to be proven and the authorities had to establish the methodology and protocols and guidelines to obtain and meet the criteria to obtain the medications. I mean, no Ecuadorian citizen can file a lawsuit versus the states to claim a right and challenge the court to obtain medications, but this constitutional ruling specifies the parameters and indicators based on which the triers of fact should rule in the cases that are filed against this court or state. Next slide, please. So then,
among these novelties, it is interesting to know that this ruling generates an obligation for being transparent. And Colombia has had some important experience in relation to the accumulation of claims and suits. And also, they have created the structures to generate these claims, and almost customized claims supported by some companies, foundations, or institutions that were promoting this kind of claims. However, some of the tracers, the most important tracers, said as an important point the generation of transparency. And indeed, the Constitutional Court says to the healthcare professionals of the public and complementary network that prescribe drugs to report the sanitary authorities if they receive compensation from the pharmaceutical industry. And also, of course, the professionals must be transparent in the conflict of interest. It is not bad to have them, but we need to report them when they have to take a decision when somebody is involved in the conflict of interest, and also to be transparent to patients, the obligations towards the patient to know if there is a conflict of interest, so that patients may have enough information to take their decisions on their own prescriptions, and in order to know more about the disease, the characteristics, and the characteristics of the drug that can they receive through a prescription. So the National Sanitary Authority says that the pharmaceutical industry is obliged to provide the information on the sponsorship of any type of activities of the professionals that could be part of this decision-making process, and also of the patients, in order to be oriented not to the access but to the irrational consumption of drugs, putting in risk their health and not improving their health situation. And also the universities, research centers, and opinion leaders, because that's the group where these marketing strategies are orienting their efforts in order to incorporate every time the drugs and breaking the access barriers, in order that people know which are the groups that may have the conflict of interest in relation to transparency, and also that the information must be public. The Ministry of Health says that it has to be public, and public from both sides, not only from professionals that could be involved in these kind of financing methods, but also from the industry that is generating the financing mechanism, in order to have information available and, if necessary, be part of any type of research or study in relation to transparency to the access of drugs. So in this context, well, the ruling has more than 100 pages and sets a lot of provisions for many sectors, because the state is structured in health providers, governance, and beyond that, it includes other kind of stakeholders, National Assembly that sets out laws of health, and also the institutes that hire public services, that generates the public purchases, and that sets out how to buy the drugs, and because we have a strategy in the country and how to purchase through corporations that are in the integral health network, in order to have an electronic catalog of drugs where you can have access, generate a purchase, and on the other side there is a vendor that has been duly selected, and that has been selected based on corporate purchasing methods. You go to a portal, you generate a purchase order, an obligation to one of the third parties in order to have an agreed price generated by the scale economy system. So in this ruling, the judge rules out and says there cannot be access if there is not one manufacturing, selling, and available in the market, and also selling in accessible prices, because in Ecuador, we have a price regulation system that has the National Council that fixes prices, that has a ceiling price, but institutionally concentrates the fringe benefits, and 80 and 90% of these benefits are concentrated in the public system, and so it generates an important market for everybody making negotiations in the pharmaceutical market. So the constitutional law says that this public hiring system must generate targets in order to reach 100% of all the drugs that are in the list of basic drugs of the national chart. There are around 800 items between pharmaceutical formulas and concentrations. And also it says to the Ministry of Health an obligation of 2 and 4 years based on epidemiological analysis, so that this list of essential drugs incorporates some drugs, but also put those drugs that even if they are in this 20% available of the list, and that is not the majority of the public policy, one can incorporate these minority drugs to have better access, and also sets to the Ministry of Health the necessary regulation it must have in order to do what we have said before. That is, guarantee transparency, declare conflict of interest, and with that, guarantee the access in order to prevent or reduce the orientation to certain groups of drugs that can improve the business plan of a certain company dedicated to that. And also says to the Ministry of Health to do a plan of measures that can mm, prevent some effects, because during the hearings they identify that some effects are related to the drug and that health is related to drugs taken by patients, while the constitution of well-being has other elements and the access to a gradual treatments. So, and here it does not put the target of preventing death, but of well-being and having the last moments of life in good moments of family without being alone in the hospital. As for example, patients receiving radioactive programs die alone, and family members cannot approach due to the characteristics of the disease. So the patient dies in total abandonment and totally alone because the other relatives cannot approach him. So the Constitutional Court says that in the well-being law, it is important to have a good dying situation by offering other kind of elements in public health, as for example, palliative elements that maybe are incorporated in fringe benefits, but they say that it must be identified by the name of palliative measures, because certainly they are not identified like that. And from there must be some spaces for these patients with these kind of alternatives. And the patients must have the right to say, I want the treatment, or I want to receive a palliative treatment as an option. And well, everything begins with the transparency and the information. And also it orders to the Ministry of Health through the Healthy Integral Network that includes public and private network to adequate these policies to provide the availability, because patients that have access to public system have the same uh, mm, mm, uh, benefits than to the private system, and those that belong to private system that receives private resources can have access to all the drugs, but the state finance some drugs, and so it must have the compliance with this kind of ruling of the court. This kind of access to all the standards and rules is complex, because there are some complex, for example, those before the Constitution, and that need to be amended. And in the following slide, the court says to the National Assembly to establish reforms to these norms. And here we have the Defense Institute of the People, that is the body that follows up the constitutional rulings. And based on this follow-up, sets out and forces this institution to follow up all the compliance with all the provisions that they have set in the ruling and follow up all the institutions involved and the National Assembly in that way that the institution that is in the pyramid of norms is disaggregated in the access means and that it is set in the public organic law and a transparency law. And from there, go to instrument step by step, that is to set out regulations issued by the sanitary authority and issues manuals and norms in such a way that they build a new analysis space to guarantee the access and meanwhile guarantee what the Constitution says, the well-being represented to have the health right and the elements of quality, safety, and efficacy. I hope that to know more about, based on my presentation, I have summarized many points, but I thought that this Constitution ruling will set a before and after. And also it's important to say that Social Security has been reduced. It was exposed to a series of demands of these drugs because we financed the 100%, and that endangered the finance for all the patients because we have treatments of $1 million per year, and we have treatments above the $7,000, $8,000 monthly. And so that is an important group. Needs increase, but not the budgets. And for that, we need also to incorporate all the efficiency elements in all the processes to start with the same budget, the enlargement of services. That is a challenge. And we consider that this constitutional ruling by decreasing the legal obligation in cases that, for example, needed to demand some brands or demand some cures, it was not possible. And as we used to have mortgage, well, then let's use that word, there were some donations to some drugs to some patients, and the first doses were donated. And so the patients wanted to have the donation of all these drugs. But so the constitutional drugs said, if somebody wants to donate, they have to donate the complete treatment. And also, for example, there was a practice where a private doctor prescribed, and if I could go to the state, and the state prevailed the prescription of the private doctor, and also the Constitution prohibited, because if I go to the private system, and then I will have to stay with it and not to the state treatment. So there are a lot of provisions, and I have tried to summarize the most relevant. And so we consider that this will mark a before and after in access to drugs, and not only in this period where all the countries are affected by this crisis and the number of deaths, but also in the pandemic, the resources, the economic resources are allocated to reduce the effects of the pandemic, and we are not able to use it in other items where we need. So now we see the crisis in relation to the use of these budgets, because we need everything, and everything is not available at the correct time. So the importance of that constitutional ruling, even though it is born to guarantee the access to drugs to vulnerable patients, well, now you cannot say that you can go into a group for this type of drugs, although the ruling puts it in that title. It regulates the national basic drugs that covers all pathologies and all the external demands of the private system were for everything, but now they cannot do it. And as a researcher from Ecuador, the, says nobody demands for having access to oral serum, to anti-parasite drug. And so it is important to rule also the demands and the SUS, where we are losing some kind of care and attention in order to fire out some little fires. So I think that that is enough. I'm here available to answer all your questions. I invite you to check this ruling and read it. And this is a complete compendium where they talk about everything, the technical points, public health, the patient, the vision of the patient, because if you read it, you will find a letter written by a patient and written by doctors where they apologize for being so slow in the public health sector and limiting the access to drugs. And also some letters that said, I have listened to everybody and also to you patients, but we believe that to guarantee the access, we need to also set some parameters. So I think there are human messages and that can be very digestible, can be read for all the citizenship, and they are very understandable. I think that the situation of the country right now and having achieved as part of that moment in which I was the leader of the defense or of the arguments of the sanitary authority is that to see that all the elements were compiled by the Constitutional Court and went beyond the testimonials, beyond what was existing. And so the court was proposing targets, gradual targets, and also compliance indicators. And the judges were told you cannot say to have access if you go out of these parameters, and also says that the sanitary authority not to issue arbitrary prescriptions and cannot be just freely using the public expenditure. And so it regulates the type of analysis in order not to distort what can be access to drugs and guarantee that right. So Jorge, until now, this is the conclusion of my presentation. Doctor, thank you very much. And I appreciate the emotion put in your presentation and that you have a lot of knowledge about law and the management you do about the ruling and the terms, the legal terms is wonderful. Thank you. We don't have a time for questions and answers, but based on the restriction of time, I will ask one of the speakers, each one of the speakers, to summarize in 1 minute which are the challenges that present the access to drugs from your perspective, from the different scopes of work where you are. So we will give the floor to Dr. Claudia. Thank you, Jorge. I think that the main challenges that we face, first of all, is the intellectual property, as I was telling you, and also Valentina spoke about it. But there are also some other aspects, for example, the recovery of the local production capacity, recover the pharmaceutical sovereignty or pharmaceutical capacity that is in every country to respond in terms of the volume of sanitary means and drugs to cover the needs of health of the population. Colombia, years ago, due to the neoliberal model, closed the plant, and now we are paying the consequences because we cannot respond quickly to the needs of the pandemic. So we need to start from zero to increase the production capacity. Thank you. Now, Dr. Valentina. Thank you very much. From my point of view, the challenge is to build an architecture, an institutional architecture at the global level that allows to cooperate among countries. Particularly, I am a passionate and turbulent Latin American doctor, so I I hope that we can expedite these, and if others can do it faster, congratulations. But I put my word to take advantage of all the lessons of the pandemic and go deeply to the main point. And so I think that the actions of this type can be potentialized in Latin America to show how united we are among diversity. Dr. Yesenia, from the reality of Dominican Republic, I think that it's important to guarantee the access to drugs in terms of the system financing and to the affiliated people. And in terms of quality, safety, and continuity of treatments, how can we make sure that the health investment is generating value added for people? So we need to consider the efficacy of treatment, the medical prescriptions, the follow-up protocols, and of course, the safety and security for patients. Yes, thank you, Dr. Yesenia. Dr. Duran? Well, I think that there is no more challenge than instrumenting and establishing the constitutional orders, because we need to reorder all the republic to the law. These rules are combined with rights, and we need to write well their laws, because sometimes are very ideological and we need to be grounded to our local needs. But I think that in the framework, we have a very top ceiling, and we need to put there into reality all the legal provisions. And so we are working together with the sanitary authority, because that is our work methodology. And I think that is the big challenge to make this ruling an operation at 100%. So I think that now we have all the points on the table, and how one cannot just act alone, and not only from an opportunity sector, but for different points of view. Because the most important is to make visible the access to drugs. Specifically, I will want to close up by quoting the words of the court's ruling. That is when it conceptualizes the access to transparency and access to drugs, and that drugs of quality and of good efficacy have to compliance, that the person has the right to have a drug to contribute to his high standard of living, and also the availability of drugs must contribute inside a health framework based on rights, where the public rights be prevailing on the top of private rights. So thank you very much to everybody, and thank you for being here after 2.5 hours, where we have been talking about access to drugs. Well, that is the main target, and we want to build from the Latin America, because having a joint vision in Latin America is necessary. So thank you to the Inter-American Conference of Social Security Studies. Well, then thank you to all of you, a group of experts.